It's clearly inappropriate law, it's biased law, only applies to certain portions of the community. There are a huge problem.
Dr. Leua Iosefa, researcher, consultant, culture specialist.
Shame, honour, mana, those things are deeply cultural and they do drive certain behaviour.
Developing tonight, the man charged in the murder of his sister's best friend pleads guilty. We've been following the so-called honor killing since 2012.
In fact, the UN has estimated that as many as 5,000 honor killings like this occur every year.
Cultural factors don't only operate to excuse offending or mitigate offending, it can aggravate offending.
What your hope is, I imagine, is that we are slowly moving towards a place where culture is better understood and integrated into New Zealand's criminal law.
There is no definition of culture and how it should be applied in New Zealand law, which is a problem. Because to prove someone's guilty of a crime, you have to prove mens rea, the guilty mind. But what if the motivations behind someone's conduct are subjective cultural factors? What happens when behaviours that are perfectly normal in some cultures get criminalised? Let's cross-examine with Dr. Leua Iosefa. This is PhD Unpacked.
Before we get into the research, can you tell us a little bit about, your background and how you ended up writing this PhD specifically?
I was born in Samoa, came to New Zealand when I was 7, so all my formal education is here in New Zealand. I did a law degree at Canterbury University, so my background is as a lawyer. I was a lawyer for quite some time. I had always imagined that one day I would do some postgraduate work, but my legal work kind of got in the way of all of that. The opportunity to do some postgraduate work arose when there wasn't much going on in Christchurch after the earthquakes. I went out to Canterbury University, did a paper just out of interest. It was a criminal law paper, and a friend talked me into doing a master's, focusing on things like fair trial rights, the right to confrontation, defining genocide. And then this friend of mine, who was also one of the academics, and he was the dean of the law school, he talked me into doing a PhD. I kind of thought about it for a wee while, wasn't quite too sure as to how to develop a thesis and turn it into a PhD. That friend moved to Massey University through his job, and I was obliged to follow him. Went up there and we kind of developed a thesis, developed a whole idea about what I could research, and it all just went from there.
And here we are, years later, after years of work.
It was challenging, but fun. It was fun, and I thoroughly enjoyed it.
And so, what point in, that master's into PhD journey did you decide that culture was going to be the sort of aspect of criminal law? That, at what point did that kind of jump off the page and you thought that actually this is the specific path I'm going to go down with this doctorate?
There was always a concern in my practice days about the whole issue of culture. There were things in the cases that I ran, the responses by judges to cultural contentions, how other lawyers perceived issues of culture. So it was kind of like perhaps building up for quite some time. The master's thing allowed me to develop the whole concern that I had about these issues. They were issues within the criminal law that I thought just were needed addressing, but no one else had done anything about it. No, that perhaps isn't quite accurate. There were people who recognised there was bias in the criminal law. There were issues about representation on juries, minorities being judges, minorities being lawyers. So there were a lot of wider issues, but the masters allowed me to kind of develop that, and So long history of concerns. The Masters allowed me to focus on certain areas, and then the PhD allowed me to expand on it all. Yeah.
So I guess to get our audience into the room, people that have never studied a law degree, people who might not know about, say, New Zealand's Crimes Act. I guess something that we need to touch on before we dive into the research is the real foundation of New Zealand criminal law, and I guess explaining that culture is not something that is defined in New Zealand statute of law, that within the 1961 Crimes Act and other legislation, culture as a concept is not defined, and that is kind of what underpins this whole piece of work, right? This piece of research of yours focusing on why we have to put more emphasis on culture and figuring out how to define it fundamentally comes from a place that it is not defined within New Zealand law, correct?
Absolutely. The whole thing about culture is that I could ask a whole room of people what their perception was of or understanding of what culture is. If I took a survey of their responses, I can tell you that everybody would have a different perspective on what culture means, what it represents to them, what other people's cultures are about. It's a concept that is difficult to understand, it's dynamic, it's eternally evolving. One culture may become something else in time. You might think that the academics have got it all sorted, but that's not the case. Back in 1952, a couple of very clever people looked into this and wondered how you could define culture. They went through, looked at what other academics were doing, and found that one academic discipline would define culture in one way, another would define it in another way, another would use different parameters to define. So it becomes quite confusing. We all have a general understanding of what culture is, but there's it's a difficult concept to define. You might be able to define it for a particular purpose, but when you actually look at what culture is, it's massive. If we go back to the criminal law, how the judges perceive culture. Every judge has a different perspective, understanding of what culture is. And it's largely because there's no definition of culture in criminal law. No guidelines. Well, this is what I found in my research. You could have things like social media culture, office culture, army culture, culture of violence, all of these things. These are mentioned by judges in their decisions. But guess what? All of those things have no bearing on the final decision because there's no set rules about what culture is, how we apply it, and how we understand it.
And that's kind of the disconnect in New Zealand criminal law, right? Because there is no set definition that all the judges, for example, are referring to when they are pondering these decisions. As you mentioned in your PhD multiple times, the inconsistencies that come out of it and the ad hoc nature of how culture is applied to different New Zealand criminal law cases, as we'll unpack down the road. That is the nature of it. Because there is no definition, it leads to inconsistencies, and that is kind of the underlying problem.
No definition, no clear understanding, no guidelines as to what do you do with it? If you do have this understanding of what culture is, how are we going to how do we get the evidence about culture into a trial? Too many ifs, no answers.
And I guess some people might think, well, what does culture have to do with criminal proceedings? I guess that is, potentially a fair question. But an important, I guess, argument within your research is that culture being undefined is a problem because, as we'll get to, there can be instances where culture and cultural factors are important to consider within criminal trials. You mentioned culturally derived motives of a defendant is an element that has to be considered
Everything you say there is absolutely correct. That's a good summary of it. There is an aspect of culture that I want to clarify. The confusion about culture as a concept is not limited to the criminal law. That's worldwide, it's universal in all kinds of fields, health, school, medicine. There are confusions. The reason why I've focused on the criminal law is because it's something I have a little bit of knowledge about, and because of my research, I've kind of developed that knowledge, and that's how I've discovered that there are all these issues. It wasn't just the little things that I was initially concerned about that got me going, but I've now found that actually these are huge things that can, huge confusions that can lead to inconsistencies, unfairness, injustices in the criminal law. I'm just doing my wee bit to kind of help resolve all of those issues. Yeah.
And so when you make this sort of case, this contention in your research about why we really need to think more in depth about how culture specifically is defined within the New Zealand criminal justice system, you point to kind of two different reasons why, specifically within New Zealand culture, more than ever, we need to consider what kind of culture means and what cultural factors are. And the first idea that you bring forward relates to this concept of super diversity, which was a concept, a word that I had never come across before. Of course, we talk about diversity a lot, but super diversity was something I'd never come across. Can you, I guess, explain that concept a little bit for us and how it relates to criminal law, specifically within this world of, in Aotearoa New Zealand, why figuring out what culture means is more important than ever as our kind of society and how public policy responds to society is continuing to evolve?
The word super diversity was developed by researchers in Europe not too long ago, and it describes a concept whereby the diversity we have in our society is supersized. Let's use that word. It's supersized just because of the now we're talking about numbers. We're talking about the large numbers of people that move from one place in the world to another place in the world, and then bringing with them their culture. Now the whole thing about super diversity, it affects how we run our schools, it affects how we provide medical services, it affects how decisions in our government are made. Everything is supersized, and our society has to deal with it. In the criminal law, it's relevant because then you have more people from other cultures involved in the court system. You've got to allow for them. Just a very obvious example is how does a woman, a Muslim woman wearing a full burqa, how is she to give evidence in a court of law, bearing in mind you can't see her face, and one of the important parts of assessing somebody's credibility is being able to see their faces. So the courts have to deal with that. You have people who go on to juries. They're presented with cultural information. So how do you present that to a juror who has limited knowledge of cultural things? Interpreters, when somebody gets sent to prison and they are of a particular culture that our present prison system doesn't cater for, how are you going to deal with providing them with food, clothing, all of these issues.
The argument, the contention that you bring about why we have to be more specific about culture within criminal law is that we have this super diversity going on, and yet the other side of the coin is that New Zealand's law is founded in this Euro-Christian centric model that is getting more, I guess, less and less appropriate to a one-size-fits-all for the diversity that is within New Zealand, and that, I guess, as the criminal law in New Zealand was instituted, now, you know, as super diversity continues to go on, it's becoming more and more, I guess, like, disconnect is a word that comes to me in terms of if we have this Euro-Christian centric foundation New Zealand law, which, as you say in your research, does have some elements of, like, for example, tikanga Māori in there. There's issues here with culture if New Zealand is getting more and more diverse, but our law has remained stagnant in how it is defining culture. Is this other problem that we have to consider?
Yeah, absolutely. In a couple of the chapters of my dissertation, I really had to look into what these issues were, what these cultural issues were, and it just snowballed. It was apparent that there were aspects of our legislation that discriminated against certain parts of our society. There's a Māori Development Act that has been on our books since 1962. But if you look closely at it, it really is just one of the worst pieces of legislation ever passed. It allows Māori to be charged if they are drunk, disorderly in a hotel. If you think that they might be too drunk and is about to drive away, you can take the keys off them. You can only charge a Māori with those offences. Now, the weird thing about it is I don't know that anybody has ever been charged, any Māori has ever been charged under that particular act.
But it's in the law.
But it's in the books since 1962. The other side to it is that why do we need those laws when we have other laws that apply to everybody? It's not specific to Māori, but it covers everybody. Why? You kind of you sort of look at that and you think, oh, there's a problem.
And so I guess within this overall idea that culture needs to be more expressly recognised within New Zealand criminal law, the starting place is that there has to be some kind of definition that we've recognised does not exist within the New Zealand criminal statute. But in your PhD, you provide a definition for both culture and cultural factors, which I recognise is no easy feat to come up with a definition for any word, let alone a word that can mean so many different things. But once you had worked through what culture was not going to be defined by in criminal law, and you came up with your own definitions, how I guess just can you talk to me about that process?
I had to search for why people behave in certain ways. There are certain aspects of a culture that has little or no relevance to why people behave in certain ways. These factors are, for example, what we eat doesn't really, how we dress, our language. So there are a range of factors. What music we listen to. So yes, the music might make us dance and so forth, but to behave in a criminal way, not so much. So I narrowed it all down and worked out that actually what causes people to behave in certain way, emotions like shame, fear, anger, protection of a cultural norm, you know. So it became quite a narrow. This all came down. Culture was very closely linked to all of these factors, and from there I developed a definition.
Yeah, and as you say in your research, to quote, the focus of the definition was on cultural factors that impact a person's cognitive processes and therefore the rationale or motivations for allegedly criminal behaviour. Once you work through all the things that might be defined as cultural or having impact on culture, that is specifically the area that when you put your blinkers on, this is what we are trying to figure out within culture, and ultimately leads to the definition, which I'll read out as a shared system of clearly defined customs, ideas, values and norms of a viable ethnic or national group, which are transmitted across a society and passed on intergenerationally, that have induced the defender's conduct. And I think that's really fascinating work to try and, I guess, analyse all the different things that culture could mean to someone, but for the process of criminal law and the task that you're sort of setting for yourself, and I guess the system is what elements of culture really matter to criminal law specifically.
Yes, absolutely. So it's important to know, to know that it's a viable culture. It's not just a couple of mates deciding to do things in a particular way. It has to be ongoing. We recognise that it's evolving. It's passed on from generation. So it's meaningful. It's the culture and the cultural factors that are applied to it are significant to a group of people. I talk about whether ethnicity is an issue, and I've largely discounted that because you can come from a certain ethnicity, which are bound by certain cultural factors, and then it evolves into something else. You move to another place. That it's important to recognise ethnicity, your nationality, but we're talking. These are things that are important within my definition. Because if you, like I said before, if you go into trying to define culture, there are such a wide range of things. It's important also to know that there are things that are unspoken about many cultures. We're talking about ideas, norms, traditions, values. So my definition really had to include those things. The vast range of those, but so when I refer to customs, values, ideas and norms, I've actually just narrowed that vast range of concepts into something that I think fits.
And that's the difficulty with this whole work surrounding culture is you're never discounting that any element of culture is less valuable or less worthy than anything else. Simply within the confines of criminal law, some things can be considered to be more relevant than others, and within creating some kind of definition, you have to refine it enough so that you're not saying anything cultural is culture, but not leaving it so razor thin that you might discount something which should be within the definition, which is why I say it's difficult to offer any kind of definition. My particular struggles in achieving this aim is really only a starting point, I feel, because if I can get the conversation going about culture, somebody else might come up with a better definition, but it's a starting point. Because as your research shows, you call it the kind of cultural order. A great chunk of your research is focused on showing ways that New Zealand criminal law has, recognised culture and liability and culpability in a way that has been inconsistent. And through the sort of chapters 5 and chapter 6 of your PhD, you present a number of different cases and examples of how the way that culture has up until now kind of been interpreted in lots of different ways, which I think we should go into to sort of explain to the audience how, it's one thing to say here's a definition of culture that we could work from. It's another thing entirely to show exactly why we need that definition, because here are some examples of the ways in which up until now culture has been interpreted in lots of different ways in court proceedings.
Yeah, as I've indicated earlier, the conclusion I've reached in my research is that it's ad hoc. It leads to inconsistencies, misunderstandings, and it's all because there's no definition and there are no guidelines. Each judge faced with making a decision about certain cultural contentions is going to apply his own culture to it, or his understanding of culture to it. It may not accord with what another judge may do. It may not accord with my definition. I just feel that if there's a basis on which everybody can work from, then we can probably address a lot of the issues that I've highlighted in chapters 5 and 6. And it's not just that the courts are having difficulty. Chapter 6 is all about how our lawmakers struggle to deal with the issue of culture. There's a number of pieces of the Crimes Act and other legislation that I refer to where it's clearly inappropriate law, it's biased law, it only applies to certain portions of the community. There are huge problems.
So I want to shift towards this idea of the criminalisation of culture-specific behaviour, that people might not kind of have a specific reference point to where culture and criminalisation might intertwine. And from all the many examples you provide in your research, the one I'd quite like to focus on is multi-partner marriages, which you spend quite a lot of time in the research, both in Chapter 5 and Chapter 6, exploring. And just as a bit of an introduction, if this is something that people haven't thought about at all, multi-partner marriages, or I guess the concept of polygamy, is illegal in the UK, much of Europe, Northern America, but is something that is not so in lots of African nations, Asian nations, some parts of Europe. But in New Zealand, the Marriage Act 1955 defines marriage as the union of two people regardless of their sex, sexual orientation, gender identity. Now we know the same-sex marriage change in law has come about in more recent years, but still within New Zealand law, multi-partner marriages cannot be performed in New Zealand or would be considered unlawful. And this, I guess, within your research, you talk about how this idea of multi-partner marriages being problematic comes from that kind of Euro-Christian cultural perspective where monogamy was seen as sort of this modern way of life and an evolution of kind of the pre-civilization idea of polygamy. And yet there's this great argument within both your research and other people's research that, you know, if we're moving to a space of time in the world where all that matters is voluntariness and the union of people based on mutual affections and love, why have we not moved to a place where multi-partner marriages are made legal? And this sort of ties into this concept of specific cultural understandings or practices that people might not realise are illegal in New Zealand or might be treated more harshly just because the kind of Euro-Christian centric foundation of New Zealand's law system doesn't allow for it. I thought that exploring multi-partner marriages within the research was a really interesting in to consider how culture might actually manifest in a specific case. Now, as you say in the research, I don't think there have been any cases in New Zealand where this has kind of come to criminal law, but it's important to consider that if this kind of framework came to a head in a case at the moment where culture is limited, exists in this space.
Well, let's just narrow it down. We're talking about bigamy.
Yes.
Under the Crimes Act, bigamy is illegal.
Mm-hmm.
So it's part of our criminal code. As you've ably described, it's a cultural thing. In certain parts of the world, it's totally accepted. Those types of relationships work perfectly fine in other countries. The bigamy has been for the whole duration of New Zealand's life, it's been illegal. It was introduced in 1893, brought over from English law. I talk about many reasons why it shouldn't be a part of our law. We've allowed pretty much every other form of union between people. This just seems to be an anomaly. You then query, well, why has it lasted so long? Why is it still unaccepted? And I guess that's just one of those things that it's a carryover from our Euro-Christian background. Researchers all over the world have argued that multi-partner relationships are a positive thing, that it's the basis of many communities. and then others who clearly come from the other side, say it's the root of all evils and blah blah blah. Their children, well, as educated as well, I haven't got an answer, but what it provides is a very good example of a cultural factor that perpetuates in our law, and I'm not sure why it continues to be criminalised.
Absolutely. I mean, this is not a podcast for you and I to sit down and discuss bigamy or polygamy.
Yes, we can go all night.
But it is an interesting to have people think about a practice that would be considered in many cultures to be perfectly normal, and as society continues to change, and as you've said, most other unions when it relates to marriage have been legalised in New Zealand. This is something that I was just having a conversation with a couple of friends before I came here today. They didn't even realise that was illegal, and I thought, well, if we're moving to a space where we want New Zealand criminal law to be more accepting of people to kind of live their lives in a way that is free, albeit consensual and formed in love and all that good stuff. Why is this practice that in many cultures, parts of the world, are considered completely normal and acceptable?
Perfectly fine in other cultures.
Exactly,
yes,
but in New Zealand law at the moment is illegal.
Don't get me wrong. I'm not advocating that we go down that route, but it's an anomaly in our laws. There are many other anomalies.
Yeah.
I think
the other example you provided, I think, about the Māori Community Development Act from 1962 was fascinating. That again, to go over it again, there's this part within law that outlines various minor offences which are applicable only to Māori and designed to regulate the conduct of Māori within Māori communities, that most people would have no idea has been sitting there since 1962 as this very, very strange way in that a specific part of our society culturally is treated in a completely different way to others.
James, I'm not claiming any credit. I'm not the only researcher that has raised this issue. Many other renowned, eminent researchers in New Zealand have been making noises about this particular piece of legislation, and I'm not sure why. I'm not. I'm sure there were certain motivations for creating that piece of legislation, but the mere fact that I don't recall in my research anybody being charged, especially when there are provisions of the Summer Offences Act and the Crimes Act that deal with these issues. Why is it on our books?
You speak to in chapters 5 and 6 the criminalisation of culture-specific behaviour, but then you also provide examples of ways in which culture has been used within criminal defences within New Zealand law cases, again to provide your PhD audience an example of how culture has been applied in different ways within cases, with there being no definition to sort of drive at how culture can be used. A couple of the cases that I thought were really interesting examples that I'd like to bring up. One was the case where the prosecution within a case contended that a particular knife that was found in a defendant's vehicle was paraphernalia for the application of illicit drugs, and the defendant argued that the knife was used for fishing purposes, and there was this great contention about, could the prosecution provide any evidence to suggest that the way that this particular item was being used was not for fishing purposes, and I think within the appeal that charge was dropped because the way that the culture was applied within that case, within defence, was deemed strong enough to...
The whole thing about that particular case was the prosecution were trying to present this particular knife as a paraphernalia for the use for drugs and so forth. It conflicted with the evidence by the defendant that it was simply a fishing knife. Now, not altogether cultural, but it sets a very good in for the what I then carry on to talk about. And there are things like, again, we've kind of not really had too many cases on it, but there are things that are cultural and provide a reasonable excuse for your carrying a knife.
Yeah,
and that's where I go on and talk about how people from the Sikh culture, they're required by their religious beliefs to carry certain items on themselves. One of those items is well, they refer to it as something else, but it has the appearance of a knife. Under our criminal law, it's an offence to carry a knife in a public place. Now, there I'm talking about how culture provides an excuse, because it's not dangerous if the item that he's carrying on him is done so for religious purposes.
And it's ceremonial.
It's ceremonial and all of that. We've had a couple of close calls where the New Zealand courts nearly got involved in a prosecution, but I think the police pulled out. There are plenty of examples overseas, though, where that particular issue was raised in front of the courts, and one case the court didn't recognise it as cultural. Another court recognised it as cultural. So, if we get to that point here in New Zealand, let's hope that we can deal with that issue.
There was a person in a case who was driving under the influence of alcohol, and the reason presented for that was a cultural pressure to comply with the request of a relative to drive that person to church. And how that case was addressed or assessed was inconsistent, in that the sentencing judge discounted the cultural relevance of the pressure within that person's culture to get that person to church. But in the appeal, the circumstances of the case and the cultural relevance to it was deemed, I guess, a special reason to reduce the driving disqualification from that person from 6 months to 3 months, which I think is a great example of how one judge assessed the case, the relevance of that cultural factor in determining what the punishment for that crime should be, and then another judge came along and did accept the cultural factor. I thought that was just clear for me to think how two different people had viewed the same case, but viewed the relevancy of culture within it in two different ways.
Excellent example, James. Absolutely. Now, what we have there is an example of two judges both recognising that culture was relevant to the offending, but applied the significance of the culture differently. I'm not sure that the judge in the lower court had fully understood, and that may not necessarily be his fault, because it kind of depends on the level of cultural information, evidence that was put before him. When I research things like that, I'm not privy to just what kind of evidence was presented, but you're right. It presents a very good example. The judge in the lower court did accept that the cultural factor was relevant, but didn't quite give it the same significance as the judge in the higher court. I think that ultimately the right decision was reached. The driver, regardless of whatever her excuse was, had committed that particular offence. It then becomes a question of, well, how serious is this? How closely attached, was she, to her cultural factor? It came down to the evidence. The judge in the lower court obviously heard the evidence. The judge in the upper court won't have, and would have, like me, gone on the basis of the notes from the court.
And these examples of cases where culture has been interpreted inconsistently kind of leads us into the sort of final section of your PhD, which, having done this sort of cultural audit of New Zealand criminal law cases, you set about making the argument about the relevance of culture to criminality and culpability. And ultimately you come to this sort of 6-part framework to assess the potential relevance of culture within any kind of criminal law scenario, which we'll get to close things out. But before that, I think it would be great to give you a moment to go through this sort of 4-stage reasoning of the steps that you take to make the argument of why culture is undoubtedly relevant to culpability, which starts with the first part, which is all about contending how culture influences emotion, and that criminal behaviour is sometimes and can be constructed around a variety of emotions. Can you explain that first step for us?
I talk about all those things like shame, honour, mana. Those things are deeply cultural, and they do drive certain behaviour. So we've reached that point. That's the kind of like the second stage. So I'm looking at, how does that affect the elements of a crime? So we've got the mental element, the intent, the motivation, the reasons why you behave, and the actual act itself. Culture impacts very important elements of an offence. Sometimes, when they're relevant, they're going to impact your decision on making about whether the intent is there and whether the act has been completed.
And that's getting to the kind of end of that 4-stage structure, which is relating, this is my words, not yours, and how I've tried to understand it, relating motive to culpability. And when you're trying to ascertain how someone should be judged for something, alleged criminal behaviour, if we're going sort of reverse engineering back to the kind of cultural factors that might have played a part, that might have determined how someone acted, and then relating that motive to liability or culpability, it's something that doesn't necessarily align with the traditional way that law interprets motive. Is that correct? That there are some arguments made within law, and again, I'm not a lawyer, never studied the law paper at university or anything, but trying to understand that sometimes within law, motive is kind of thrown out the window. But an argument that you are focusing on is we must consider how someone's cultural background, their cultural factors, may have played a part within any given scenario or proceedings, and that must be taken into account when you might be judging someone and figuring out how to sentence them for some kind of crime that might have been committed.
Yes, there's an attitude, a very ancient attitude in law that motive shouldn't matter, but there are instances when motivation, your reasons, your rationale for doing something that might be considered as criminal is relevant. So I'm talking about those things. Already the law requires the consideration of motivation, because it goes to your reasonableness. We've talked about some examples of that. Proportionality, whether the offending was serious or not so serious, or not serious at all. There are things like provocation. Those are relevant. They've always been a part of our... Sorry, I qualify that. Provocation was a defence to murder. It no longer is. but it's still a consideration in terms of a number of other offences. So we're still required to talk about provocation because it's still relevant in other parts, just not as a defence for murder. Motive you can't discount. I realise I talk a lot about it, and I try and discount the whole theory that it's irrelevant in some cases, but there are very specific examples that I give where motivation, a person's rationale for acting in a particular way is significant and is relevant.
And that brings us to the framework of relevance. Within your PhD, you suggest as a framework that could be used to determine whether culture is relevant, should play a part in culpability. Could you, in whatever brevity or detail feels appropriate, take us through those steps? Because ultimately this is where your research gets to. When you're assessing how culture might align with a case, there's this sort of 6 steps that you provide for if we're going to operate in a situation where we're assessing, are there cultural factors that have played a part within proceedings? How can we assess how relevant culture is within that situation? I think the first element that you speak to is the culture valid, and is that the idea that can the culture that is being referenced as a defence be seen to be
yes, I have talked about that. Yes, it has to be a valid culture. There has to be viability in the culture. Again, we go back to the wide variety, the multitude of cultures that there are out there. A judge in a court deciding a particular factor is going to want to know whether this is a bona fide culture or just a bunch of guys making up rules to suit themselves. So yes, that is an important element, and that's you have to start from that.
That's absolutely the start point, and then the next step that you move into is identifying a specific cultural factor within this valid. If we've determined yes, there's a valid culture here, is there something specific within that culture, a factor that has played a part in the proceedings, something specific that can be pointed to?
Absolutely. So it's all very well being a part of a cultural group and obeying the rules or traditions, norms of that particular group. But you have to demonstrate that you have some connection with that culture. You've been brought up within that culture. You have an understanding of the cultural factors that are involved, and it has affected your behaviour. Now, big world we live in. I'll use myself as an example. I came here as a 7-year-old Samoan young man. I'm Samoan, Tongan by ethnicity, but I've lived most of my life in New Zealand. Now, you're going to be wondering, well, what connections does that guy have with his Samoan culture? That's really what I'm trying to get. A judge is going to go, oh, okay, he is a Māori person, has lived in his, another example, a Māori person, he's lived in Auckland City all his life, had no connections with his culture. Why is he now claiming that cultural factor as having impacted? So there has to be that connection throughout my dissertation. I talk about a thing called whiangainga and how it affects the behaviour of Pacific Islanders, Samoans, Tongans. They are a well understood cultural factor. Everybody knows what it is, knows the expectations of it. It's not written down, just everybody understands it. So if you're relying on a factor like that, you're gonna a judge who has little or no understanding of that particular fact is going to want an explanation of
The third aspect is the connections with this asserted cultural factor. The fourth is, has the cultural factor induced the defendant's behaviour? Is there a link that can be drawn between the alleged criminal act that has been conducted and the cultural factor that is kind of being claimed? And that moves us into the last kind of steps of the framework, which is the cultural factor relevant to the mens rea? And is the cultural factor relevant to the defence? It's all very well to point out that, yes, this culture is valid, there's something specific within the culture that can be pointed to, yes, this person has a connection with that culture, yes, that cultural factor might have induced the behaviour, but is it relevant to the defence? And this is this whole point of, we could have a definition of culture, we could provide a framework, but that doesn't necessarily mean that in every single situation cultural factors would be seen as a mitigating factor, say.
Absolutely. So perhaps a good example we've already talked about is the Hamilton case. If my framework had been applied in that particular case, we would have found out that the culture was real, the cultural factor was significant. We would have discovered that there was some connection between the driver of the car and that culture and that cultural factor, and she behaved on that occasion under those circumstances because of her compliance with that cultural obligation. One thing that needs to be remembered is that cultural factors don't only operate to excuse offending or mitigate offending. It can aggravate offending, and I do give plenty of examples of that when I talk about what media refer to as honour crimes. That's an example where perhaps the rationale or the reasons for committing a murder or can aggravate an offending.
And that brings us sort of back to the start, the top of this whole subject, and the whole drive for this piece of research is simply that because there is no definition for culture within New Zealand criminal law, the way that judges are responding to cases within Aotearoa where there are cultural factors at play, inconsistencies are simply going to arise because they're having to work within a system that does not define what culture is, does not define what cultural factors are applied in, and does not utilize necessarily a framework within how to work through it. And that's kind of appropriately brings me to this one of the last questions, which was, I guess, thinking about how you publish your PhD, you've got the framework. How has your PhD been applied in the work that you've done since the PhD has been published?
My doctoral research was very specific. It covered a particular area of the criminal law. I'm very proud of that, but it actually raised a whole lot of questions about other things. Like I didn't have time to look into, well, how do you present evidence of culture? And we don't have any rules, no framework, no guidelines about that. So yes, that's an aspect of research that I'm looking into. Part of my present work is that I write cultural reports for the court. Now that's under Section 27 of the Sentencing Act. How Section 27 is developed, I'm relatively proud of that, because we had a previous version of that, and there was hardly any use of it. There was hardly any, but like in the last few years, that's become quite a useful tool in sentencing. So I've become involved as one of the providers of those reports. I thoroughly enjoy the research involved in that, and I'm not afraid to say, or embarrassed to say, that in the back of my mind, when I'm preparing these reports, I'm thinking about all the things that I've been preaching in this dissertation, and I would like to think that I'm trying to develop a certain style, and hoping, in the hope that there's better appreciation of the whole, all the questions about culture and cultural factors.
And ultimately that we perhaps move forward to a world where culture is... I mean, I have absolutely no idea how these things get changed within New Zealand law. Again, not a law student,
Slowly.
never touched a law, slowly. But ultimately, what your hope is, I imagine, is that we are slowly moving towards a place where culture is better understood and integrated into New Zealand's criminal law systems.
Before there was kind of like, just culture. Now acknowledgement of culture is more meaningful. Some judges, not all of them, are starting to recognise the significance of it, and I'm nothing to do with me, but I'm proud of those developments. I would like to think will happen from my PhD is that there's more discussion about it, more research. I'm only talking about the criminal law here and a very small aspect of the criminal law. Culture may hold other concerns, other issues for other areas, schools, hospitals, the building of our roads. I'm only concerned with the criminal law here because it's a big thing, the law. Yeah.
Well, thank you so much for taking the time to be a part of PhD Unpacked and coming on to have a discussion about your fantastic piece of research, the significance of culture and cultural factors in New Zealand criminal law. Thank you so much for being here.
Thank you.
Thanks for watching this episode from Season 3 of PhD Unpacked. For previous episodes from this season and Seasons 1 and 2, check us out on Spotify and Apple Podcasts, as well as other listening platforms, and follow us, PhD Unpacked, on Instagram and TikTok.